You have spent years building a California real estate portfolio, multiple properties with low tax bases, and luckily significant appreciation has happened so far. Now you want your children to inherit that legacy without getting them tied up in court and hit with punitive taxes. The stakes couldn't be any higher. If you rely on a simple will or no estate plan at all, your estate could be tied up in probate court for 12 to 18 months and sometimes even longer than that, racking up tens of thousands in fees. California probate is notoriously slow and expensive. Hi, I'm Ali Talai, an estate and asset protection attorney and also founder of Talai Law Offices, and I have seen families wait well over 2 years just to get clear title to a family home. But the real kicker is what happens with property taxes. Under Proposition 19, transferring property to your kids, even while you're still alive, can trigger a full property tax reassessment, drastically increasing annual taxes. That could mean your $3,000 tax bill could suddenly jump into $15,000 or even more every year, a burden that can quickly turn inherited or gifted property into a liability. And if you're in a higher net worth category, a good problem to have, Congress just passed the Make American Workers and Families Thrive Again Act, which sets the federal estate tax exemption at $15 million per person starting in 2026. It will be indexed for inflation moving forward. That is a game changer for high net worth families. However, even with the higher exemption, proper planning is key. Having the right and appropriate irrevocable trust, the LLC planning, gifting strategies still play a powerful role, not just for tax savings, but for protecting your legacy across generations. The bottom line is this: passing real estate to your kids in California requires careful planning to avoid probate delays, minimize taxes, and keep the wealth intact for the next generation. Let me walk you through the tools and strategies to do it the right way. For most Californians who own real estate, the Revocable Living Trust is your foundation. Holding your property in a properly funded revocable trust allows you to bypass probate entirely, which means your children can inherit without going to probate court, avoiding a long, expensive, and public process. Unless you don't like your kids, then at that point you let them go to probate. One final parting gift. Your successor trustee can step in and distribute assets privately and efficiently, saving your family time and tens of thousands in probate costs. But here is where things get even more powerful and often overlooked: the tax advantage. Assets in a revocable trust remain in your taxable estate, which means at your death, your children receive a step up in cost basis. Their tax basis gets adjusted to the fair market value as of the date of death. For example, if you bought a property for $300,000 and it is now worth $1.5 million, the capital gains could disappear for tax purposes. That can save your heirs hundreds of thousands of dollars. Now, here's the critical part. If you are married and you have a joint trust, you may only get this step-up basis at the first death and not fully again when the second spouse passes away. And you might be asking why. And the reason is that many joint trusts, they're drafted with rigid bypass or credit shelter trust provision that locks in the basis of the first spouse's share, preventing a second step up at the surviving spouse's death. To preserve that second basis adjustment and still allow for estate tax planning when needed, we often include a testamentary general power of appointment formula clause. This lets the surviving spouse trigger estate inclusion at the second death if estate tax isn't a concern at all, resulting in another full step up in basis. If tax planning is needed, the trust can still use traditional strategies like credit shelter funding. The result is that your trust adapts to the tax environment at the time of death, and your children get the most favorable outcome. All right, so let's talk about limited liability companies, LLCs, one of the most versatile tools available to real estate investors. But let's be clear, just forming an LLC doesn't make you immune to lawsuits. It doesn't work that way. Yes, your LLCs are designed to create a legal barrier between your personal assets and your business and rental properties, but in reality, property owners often get pulled into lawsuits because opposing attorneys will argue that you were personally managing the property, making key decisions, or failing to delegate responsibilities correctly or properly, in which case they try to reach your personal assets anyways. That said, when structured and maintained properly, LLCs can provide two critical types of protection. First, they help guard against inside liability, lawsuit that arises from the property itself. For example, if you have a tenant that slips and falls or claims dangerous conditions in the rental property, the lawsuit is directed at the LLC. Second, LLCs can also help protect against outside liability, claims that have nothing to do with the assets of the LLC, the property, or whatever you're holding inside of your LLC. Let's say you're involved in a serious car accident and the other party obtains a large judgment against you personally. If your real estate is held inside an LLC and structured correctly, those assets can be more difficult for a personal creditor to reach. This layer of asset protection adds a long-term security for you and your family. In short, LLCs serve as a two-way shield, insulating you from property-related lawsuits and insulating your properties from your personal liability. If you own multiple properties, you might even consider using a separate LLC for each one of the properties. That way, if property A, for example, is involved in a legal dispute, it does not automatically put properties B, C, or D at risk. But LLCs aren't just about asset protection, they're also incredibly useful in estate planning. Think of your LLC as a holding company for your real estate. Instead of titling each property directly to your living trust, you can have your trust own the LLC's membership interest. And when you unfortunately pass away, your children inherit the LLC through your trust, bypassing any probate while keeping ownership streamlined without the need to inform the tenants, without the need to update the lease agreements. Things can run a lot smoother if done this way. LLC interests also make it easier to transfer ownership gradually. You might want to give 10% of your LLC to a child. And again, you would do that through a trust. You never want to do outright gifts to children. In most cases, it doesn't make a whole lot of sense. And so by having this LLC in place, you could actually do that. And because we're not recording anything, it allows us to make the transfer without any property tax reassessment. There are certain nuances to it, which I'll touch on in a little bit, but it allows more flexibility when it comes to gifting. And one of the other benefits is that minority LLC interests can qualify for valuation discounts. That means a 10% non-controlling interest in your family LLC that you just gifted to your child can be appraised at less than 10% of the underlying real estate value because the recipient lacks control and marketability. This can translate into real savings on gifts and estate taxes. LLCs offer real protection and flexibility. When used correctly, they allow you to insulate risk, avoid probate, maintain tax advantages, and pass on a property in a strategic way that supports both asset preservation and legacy planning. All right, let's talk about Proposition 19. When California voters passed Proposition 19, it significantly narrowed the long-standing parent-child exclusion from property tax reassessment. Today, unfortunately, no living trust or will, no matter who's drafted it, even if I have drafted it, can automatically prevent reassessment when real estate passes from one generation to the next. The only meaningful exception now applies to a parent's primary residence, and even that comes with strings attached. For your child to qualify for the exclusion, they have to move into the home and make it their own principal residence within 1 year of the transfer. And even then, the protection is limited. It only shields up to $1 million of value above the parent's current assessed value. Anything beyond that gets reassessed. Let me try to show you how quickly this can become a problem. Suppose you bought your personal residence 30 years ago for $250,000. Today, thanks to Prop 13, it is assessed at $400,000, but the fair market value of the property is $2 million. If your child inherits that home and doesn't move in and claim it as his or her primary residence, the county assessor will gladly revalue it at $2 million. And with California property taxes hovering somewhere between 1 to 1.25%, that would result in the annual property taxes to jump from $4,000 to $5,000 to $25,000 every year. So even though exclusion might help one child stay in the family home, it is completely unavailable for other types of real estate, like your rental property, vacation homes, or investment properties. Even if those homes and those properties are held in a living trust, they will still be reassessed upon transfer. That's why many families start exploring alternative planning strategies like LLC fractional transfer approach. But as we will get into next, that strategy also comes with its own set of rules and limitations. All right, so let's talk about a strategy that gets a lot of attention when families are trying to avoid property tax reassessment in California, and that is putting real estate into an LLC and then gradually transferring ownership to children over time. On the surface, it sounds like a clean way to keep property in the family, preserve that low Prop 13 tax basis, and avoid reassessment. However, and in some cases, it actually can work, but only if it's done very carefully and under very specific conditions. Here's what you need to understand. California law treats entity-owned real estate differently depending on how the property ended up in the LLC. If the LLC was the original buyer, meaning it acquired the property directly and the deed was recorded in the LLC's name in escrow right from the get-go, then we're dealing with what is called a change in control rule under Section 64C of the Revenue and Taxation Code. In that situation, the key trigger for reassessment is whether any one person or entity ends up with more than 50% of the ownership or control of the LLC or the entity. As long as no one crosses that threshold, the property tax basis remains untouched, even if you slowly transfer a small percentage over time to children or to their trust. This is the cleanest and most predictable way to use an LLC to preserve the tax basis. But the strategy becomes riskier when the property was originally owned in your individual name or in your trust, and then you later transferred it into your LLC. That's when a different rule kicks in. That's going to be under Section 64D, which tracks what is called a cumulative transfer of interest rule. Under that rule, even if no single person gains control, the properties held under the LLC will be reassessed once more than 50% of the LLC's ownership interests have cumulatively changed hands since the property was first contributed to the LLC. That means if you're giving away 10% or 15% to different children and beneficiaries, it can quietly add up in the background. And if you go over that 50% mark, the entire property gets reassessed. No warning, no partial reassessment, just a full reset of the tax basis. And California assessors are paying attention to this these days. And these days, California assessors are paying close attention to this. They are watching entity level transfer much more closely than they used to before. And if they suspect a change in control or cumulative transfer has occurred, they are not afraid to reassess and send you a new tax bill. Now, even with all this in mind, there are ways to use LLCs creatively without giving up the income tax benefit that comes with inheriting properties. And I'm going to get a little technical here, so bear with me. One of the options is to transfer the LLC's interest into what is called an incomplete gift grantor trust. That is a kind of a trust that is treated for income tax purposes as a still belonging to the original owner. So when that person passes away, the LLC's interest inside the trust can still get a full step up in basis to fair market value. That can dramatically reduce or even eliminate capital gains taxes if the property is sold later on. At the same time, because the gift is incomplete, for transfer tax purposes, the structure may help preserve the existing property tax basis as long as the trust is drafted correctly and the ownership transfers do not trigger a reassessment under the cumulative or control or change rules. So during your lifetime, you can keep the property tax benefits, and at death, your heirs, your children, can receive a fresh tax basis for income tax purposes, giving them flexibility to either hold or sell without facing a huge tax bill. Now let's turn to estate tax and irrevocable trust planning, the more advanced side of passing high value portfolios. Previously, the federal estate tax exemption was set to drop in 2026, but a new law has made the higher exemption permanent. Now, every individual, citizen, green card holder will have a $15 million estate and gift tax exemption, which will be indexed for inflation. If your net worth, including real estate, is well above those figures, you can face a 40% federal estate tax on the amount over that exemption. California has no estate tax. I think they forgot about this thing, but that federal tax alone can be devastating. One way to combat this is to remove assets from your taxable estate before they appreciate any further. Let's talk about some of the plannings that can be done. And the main idea is that we want to put a plan in place that allows you to remove the assets away and out of your estate so that any future appreciation will be outside of your estate. You might create an irrevocable gifting trust for the benefit of your spouse, your children, and future grandchildren, and gift one or more properties into that trust now. If done properly, those assets, plus all their future growth in value, will be outside of your estate when you pass away, and because they're not considered to be part of your estate, there'll be no estate taxes calculated on those assets. For instance, if you have a $30 million estate, good for you, you could gift $15 million of the real estate or any other portion of it into an appropriate estate tax planning trust now using your exemption. That $15 million most likely turn into $20, $25 million in the coming years, and all of that growth will avoid the 40% estate taxes. The trade-off is the income tax basis. When you make a gift during your lifetime, that means the trust or the person who acquires the gift also acquires the original basis to the property. And at the time you pass away, there'll be no step up in basis for the assets that were transferred into a trust like this, or if it was gifted to a child directly. That could mean higher capital gains taxes if they sell the property later on. There are ways to be able to create these kind of a trust that we could build in some capital gains tax planning as well. It's definitely more sophisticated. We'll talk about it in another video for sure. Talking about sophisticated plannings, there are sophisticated versions of irrevocable trust that can provide even more benefits. One of the popular approach is a trust that is referred to as an IDGT, intentionally defective grantor trust. And this is an irrevocable trust that is defective in a good way for income tax purposes, meaning that you still pay the income taxes on the trust assets during your lifetime, and this will allow the trust to grow unencumbered by taxes. The other way you could use these IDGTs is that you can sell properties to this intentionally defective grantor trust in exchange for a promissory note, freezing the value in the state while further growth happens inside the trust for the benefit of the kids. And under Revenue Ruling 85-13, as long as the sale is for fair market value and adequate consideration, it can be an effective wealth transfer technique. Most often, the best solution isn't one single tactic. It's a combination tailored to your family. A common plan for a high net worth client might include a revocable living trust as a centerpiece to avoid probate, an LLC to hold real estate portfolio for liability protection, and perhaps one or two irrevocable trusts to start moving value out of your estate and creating a strong asset protection plan. The goal is that when the time comes, your children inherit your real estate smoothly, your assets smoothly, privately, and with as little tax burden as legally possible. No messy probate fight, no fire sale of properties to cover taxes, and no sibling dispute because the plan wasn't clear. If you want to make sure you're not missing any of the foundational step in your estate plan, I am hosting a free webinar, The 5 Biggest Estate Planning Mistakes and How to Avoid Them. In this webinar, I will walk you through the most common traps I see, mistakes that can cause probate, trigger unnecessary taxes, or leave your family in a legal mess. It is free to attend, but you do need to register to save your spot. And to do that, you can visit our website, talailaw.com, and that's TALAI law.com, or just click the link in the description. If this video was helpful, do me a favor, hit like, subscribe, drop a comment if you have questions. Now that we've covered how to pass your California properties to your kids while avoiding probate and tax pitfalls, you have taken a big step towards protecting your family's future. But a plan is only good as its execution. One critical step is making sure your trust is properly funded. That means that your assets are actually titled or somehow assigned and connected to the trust. So at the time it really needs to work, it will actually work. So don't miss my next video, 5 ways to fund your living trust. I will walk you through exactly how to move different assets into your living trust, including real estate, to ensure all of this planning pays off when it counts. I look forward to seeing you over there.